Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of the FBAR penalty and if it's issued per form or per violation. Let's start with the basics. Who has to file an FBAR? Basically, U.S. persons, which means U.S. citizens, legal permanent residents, and foreign nationals who meet the substantial presence test. Dual status taxpayers may have to file the FBAR if you're only a U.S. person, kinda, sorta, because you filed a 6013G election to file along with your U.S. spouse, and that generally does not put you into the U.S. person category sufficient to have to file an FBAR. In reviewing what has to be reported on the foreign bank and financial account form, it's essentially accounts and investments. With the FBAR, it's technically foreign bank and financial accounts. With the Form 8938, it's specified foreign financial assets. As to accounts and the FBAR, it's going to be things like investments, investment accounts, stock accounts, fund accounts, life insurance if there's a surrender value, foreign pensions, and possibly foreign business accounts, depending on a couple of different factors. The FBAR has a $10,000 baseline threshold. What that means is if on any given day of the year, you have an annual aggregate total of more than $10,000 in offshore foreign accounts, assets, or investments, then you're required to file the FBAR. FBAR is not filed with the IRS. It's filed directly with FinCEN, which is the Financial Crimes Enforcement Network. Take a deep breath and try to remove the crime portion of that definition out. It's rare if ever that a person gets dinged with criminal penalties, or more specifically that the IRS refers the matter for criminal enforcement. The FBAR is required to be filed at the time that a tax return is filed, April, June, October, possibly December. If you want to apply for an extension, you technically don't have to. It's still on what's called automatic extension. So taxpayers generally have until October to file a tax return. They base it on the idea that if you're in the U.S., you have until April to file a tax return, and then you get an automatic 6-month extension in the U.S. to file the FBAR. What happens when you're non-compliant, right? The purpose of this presentation. So, you never heard of the darn form, you filed it untimely, you filed it late, you filed it incomplete, whatever other issues may come up. Well, the IRS loves to hit you with penalties. There's two main categories of penalties: civil versus criminal, and then willful versus non-willful. Let's focus on the non-willful. When it comes to non-willful penalties, it essentially can be broken down into 4 categories. A penalty waiver, yay, right? A warning letter, it doesn't go on your permanent record. One penalty for the whole entire enchilada. Let's say that it's 6 years of non-compliance. They ding you with one $10,000 penalty. That $10,000 penalty adjusts for inflation. Right now, it's about $13,500. They could hit you with a $10,000 penalty per year, 3 to 6 years. 6 years is the FBAR statute of limitations. Or if you get the worst guy or gal on the worst day of their career and they just don't like you, well, they could hit you with a $10,000 per violation per year penalty. So up to 50%, because your non-willful penalty can exceed what the willful penalties would be. Just for reference purposes, the willful FBAR penalty is the greater of 100,000, also adjusted for inflation. I think it's around 130 and change, or 50%, whatever's higher. So your floor is going to be that 130 plus $1,000 penalty. Courts are not consistent in what they have determined for the FBAR penalty. Is the non-willful penalty per form or per violation? So it depends on where you are, what the jurisdiction is. The district courts are split. Some courts will say that it's per form. So that would limit you, if you had 20 accounts on there, it would limit you to a $10,000 penalty per form. Other courts have not taken that position and have basically said it's per violation. So if you have 4 missing accounts in a year, you have to file the FBAR, and you're non-willful, they can get you for 4 or more, depending on how many accounts you have. One way or another, if you're out of compliance, you should consider getting into compliance before this becomes an issue. and you can normally sidestep or circumvent the penalties by doing one of the voluntary disclosure programs. If you were willful, you could do the voluntary. Well, if you're willful, the only option you have is voluntary disclosure, VDP. It used to be VDP and OVDP for offshore. Since September 2018, it's all been meshed into one program, voluntary disclosure program, or VDP. If you're non-willful, you have many other options available to you. Streamlined filing compliance procedures, which is broken down into streamlined domestic and streamlined offshore. You have reasonable cause. You've got the delinquency procedures. There's a specific delinquency FBAR procedure, which basically says if all you have is the FBAR, you can basically do this and skate away without penalties. They used to have the delinquent international information return submission procedure as well, and they still have it, but as of early November 2020, it's been sort of mutated into a reasonable cause submission. So there's not necessarily any preferential treatment for filing delinquency over straight reasonable cause submission. We have lots of free information available on our websites. If you think it's appropriate, you can reach out and schedule a reduced fee initial consultation. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.